And how does the belief I'm no longer a citizen directly lead to costly exit tax mistakes?
Well, I am no longer a citizen in and of itself makes no direct change to your tax residency status, nor does it have a direct impact on your filing obligations. You must engage with residency through the eyes of SARS and filing obligations separate to the relinquishing of citizenship. Exit tax can become a sticking point for taxpayers.
Hi, I'm Tasmin Kotze, Tax Legal Associate with Tax Consulting South Africa. And today I'll be interviewing Delano Abdoll. Hi, Delano, and thank you for joining us today.
Tasmin, thank you so much for having me here. I very much look forward to today's conversation. I think very valuable to our viewers and interested to hear what today's questions are.
Thank you, Delano. So today we'll be discussing common misconceptions among South African expats who have left the country and the relationship between citizenship status and South African tax residency. Do you have any opening thoughts or remarks on this for us today?
I think a good starting point is there is quite an intensive drive from SARS over the last few years to collect as much tax as possible. On a recent article I read over December, reference was made to South Africa having around 62 million in the population size, with only around 9 million being individuals who are registered for tax and actively engage with SARS in terms of filing returns. And with that backdrop, it becomes incredibly important for expats who are abroad, who have a view that because of relinquishing their South African citizenship, they are no longer on SARS's radar for tax collection. This is something that we can really deep dive and perhaps give certainty and clarity on a couple of misconceptions that our viewers might still have in this regard.
Thank you, Delano. In short, does changing or renouncing South African citizenship automatically expunge a person's tax liability in South Africa?
So the short answer is no. And the reason for that is relinquishing citizenship is by no means a criteria or regulated requirement from a SARS perspective to either deregister an individual from tax, to update their status from a resident to a non-tax resident, or to give confirmation that there is no filing obligation from a tax perspective. So the mere fact that someone relinquishes South African citizenship does not in and of itself mean that in the realm of tax, their obligations, liability, and duties to inform SARS of formally seizing their residency has been satisfied.
And can you explain to our viewers perhaps how that relinquishing of your tax obligation in South Africa may look today, or what confirmation you may receive from SARS which expunges that duty to, or your tax liability in South Africa?
So I think where the problem arises is you have a group of South Africans who have left South Africa many years ago. So much so that they are now at a stage where, in addition to setting up a base abroad, they have actively chosen to relinquish their citizenship. A few years later, they are now confronted either by policy administrators or their banks to produce confirmation to SARS that they are non-tax residents. And with this, there could be the conception of, well, I relinquished South African citizenship. Is that not enough? It is not enough. And they now need to provide either a policy administrator or, for instance, an authorized dealer like a local bank with a so-called Notice of Non-Resident Tax Status Confirmation Letter. And obtaining this letter means you have to actively engage with SARS through a formal request to obtain the document. The relinquishing of citizenship, yes, can be a strong indicator of maybe why you should be viewed as a non-resident, but is not in and of itself a satisfying of SARS's verification requirements. And I think that is where the confusion often arises. I think also on a day-to-day basis, what we see is that taxpayers are of the view that because they've relinquished their South African citizenship, they feel that they are not able to engage with SARS for some odd reason, albeit that they still have an active tax number which relates to them filing tax returns in respect of personal income tax. So this is usually what we see on a day-to-day basis. And it's important that if you are a taxpayer still registered for tax with SARS and you have not yet formally seized your South African tax residency with SARS, you must engage with someone to assist you in obtaining confirmation through a SARS-issued Notice of Non-Resident Tax Status letter.
Thank you, Delano. And if someone renounces South African citizenship tomorrow, what, if anything, changes from SARS's perspective?
So we have to make a distinction here that when we talk about South African tax residency, we are in a SARS building. When we talk about citizenship, we can talk about the Department of Home Affairs. The two are not the same building. Rules of breaking tax residency in South Africa are strictly regulated by the Income Tax Act, and more specifically, the definition of resident within that piece of legislation. That definition, from the beginning to the end, does not mention citizenship once. There are then certain interpretation notes that we often use as tax practitioners and advisors to help navigate for our clients what is SARS's interpretation of classifying yourself as a non-resident. Because the definition is written from the positive interpretation of what is a resident. If you do not satisfy the definition, you in turn should be viewed as a non-resident. Citizenship comes up in one of SARS's interpretation notes, more specifically Interpretation Note 3, which deals with our first test in South Africa called the ordinarily resident test. There are a list of 13 objective factors which SARS may consider in verifying whether a taxpayer is indeed not ordinarily resident or if they are ordinarily resident. And that factor specifically mentions one's status, their immigration status or citizenship, and more specifically, whether or not that person, for instance, has permanent residence in South Africa. So, by no means is relinquishing citizenship translatable to or equating to one automatically qualifying as a non-resident in terms of the Income Tax Act. There are multiple factors to consider, and it is but one factor that you could use as part of your application to motivate to SARS why you should be declared as a non-tax resident.
Okay, very interesting. And in terms of trigger events, what exactly could cause SARS to reassess somebody years after they've left South Africa?
There can be multiple trigger points, but essentially you're looking at a group of individuals who may or may not have registered for personal income tax before relocating abroad. I often find that there is a large number of expats who actually relocate abroad without being registered for tax. And they might have relocated for purposes of studying abroad, or at that point in time, they were not yet earning an income to be registered for tax. And where that obligation arose for them for the first time was when they secured employment abroad. They then are of the view that because the income is being sourced abroad, they will register as a taxpayer in that country without informing SARS of them now being employed abroad and paying tax abroad. So where they often circle back to SARS is now wanting to either receive inheritance from a family relative who is still in South Africa, or it could be that they are planning to relocate to South Africa and would like to know, once they are on SARS's radar, how will they be viewed by SARS from a tax residency perspective, considering that they've been out of the country for so many years. So as a trigger point, it's getting money out of the country with SARS compliance, alternatively wanting to relocate to South Africa and wanting to make sure that when they relocate, SARS will not flag historical non-compliance as an obstacle for their retirement plans.
I think that's a very important point that you raise, is that historical non-compliance. It's one thing that we see on a regular basis, is SARS actually coming after expats for annual returns not filed for various years. Do you have any comments on this?
Look, strict letter of the law is that once you've registered for a tax number, tax should be assessed on a year-to-year basis. A year of assessment in South Africa runs from 1 March up until 28 or 29 February. And you really need to manage your South African tax affairs through your e-filing profile registered with SARS, ideally on a year-to-year basis. That, for me, is the prudent way to manage tax. And when you file a tax return, you must also keep in mind that SARS is honing in on whether the return is filed on the basis of the individual being classified as a resident, or is the individual to be classified as a non-resident. This is going to be paramount, in my view, for the upcoming filing obligations for those taxpayers who need to file a tax return for the 2026 year of assessment.
Thank you, Delano. And let's talk about exit tax. Why does this shock some people who are no longer in South Africa and who seek to cease their South African tax residency?
I think it's really down to a view of paying the taxman more. And why should taxpayers be paying the taxman more? So there are very strong views around expats having to actually pay SARS tax on SA-sourced income, foreign-sourced income, capital gains tax when they sell properties, and now still an exit tax, having paid VAT while they were here, and so on and so forth. But these are all views that stem from what is the legislative position. The position in law is that when you update your status from a resident to a non-resident, it triggers a so-called deemed exit tax event. The actual charging provision of that event is Section 9, capital H of the Income Tax Act. So regardless of your view, it is in law the position from which SARS can levy a tax liability.
Thank you, Delano. And how does the belief I'm no longer a citizen directly lead to costly exit tax mistakes?
Well, I am no longer a citizen in and of itself makes no direct change to your tax residency status, nor does it have a direct impact on your filing obligations. You must engage with residency through the eyes of SARS and filing obligations separate to the relinquishing of citizenship. Exit tax can become a sticking point for taxpayers if prior to them leaving South Africa, they actually were in a position where they had a considerable asset and investment portfolio. And after the fact, now wish to seek written confirmation from SARS that they're non-resident. They might end up being stuck with a very factual cessation date. And as of that date, it will open up an inquiry from SARS as to what assets they held. And this will then ultimately result in a calculation having to be done and them having to declare to SARS that after their non-residency is confirmed, they've indeed paid SARS exit tax. So there's no escaping that. In a perfect world, it's always good to plan your cessation of residency before you leave South Africa, as opposed to catching wind that SARS is actively looking for taxpayers who have left the country and have not formally engaged with them on confirming, or as I'd like to call, regularizing their exit per SARS records.
Okay. And if change in citizenship and in residency does not in and of itself impact tax status in South Africa, what should South Africans focus on when leaving South Africa? As we say, as those wheels take off the runway, what should they be concerned about?
Well, I think if you know that you'll be relocating, I often find that most expats relocate for employment purposes, and they are still in their life cycle actively looking for opportunities to earn remuneration, and would like advice to ensure that that remuneration is not double taxed. So to be proactive, one should seek advice to actively plan the tax exposure of foreseeable income and really see how can this either benefit you or put you at risk for your medium to long-term plans. Certainly, I would not advise leaving South Africa with a view of not informing SARS of that fact. Maybe seeking advice and seeing when you engage with SARS on this exit point, what are the tax implications around that? And that then puts you in a position where you can make informed decisions and know what is the direct impact to the pocket.
And at which stage would you suggest is it important for expats to engage an expatriate tax consultant or specialist?
Conservatively, I would say anywhere between 6 to 1 month before leaving South Africa. It is, however, possible to do requests to SARS for a non-resident status, having the application backdated to the factual position. But that can also bring about a few challenges, such as finding the actual passport that evidences your stamps of when you exited South Africa and when you entered the country you relocated to. But if you are the type of taxpayer that manages documents and manages the type of information that SARS would need for verifications and audits on a year-to-year basis, then it's a very small, if not irrelevant, stumbling block. But the overarching principle that taxpayers should be aware of is that in South Africa, the burden of proof is always on the taxpayer. taxpayers carry that burden of proving the position to SARS, whether on a backdated basis or for a current or upcoming tax return basis.
And lastly, for South African expats who have left the country already, maybe 5 to 10 years ago, what are the compliance risks and what should they be aware of?
Well, I think no one wants to be in the bad books of the taxman. No one also wants the unknowing surprise of having a considerable tax bill after planning their savings and their lifestyle and retirement without considering that they might still owe the taxman something. So getting peace of mind on what is the actual tax position and is it confirmed by that revenue authority would be sound advice sooner rather than later.
Thank you to our viewers. I think the key takeaway from today's session is that changing your passport doesn't automatically change your tax liability. It's important that South African expats consult with and engage tax specialists to ensure that their affairs are formally ceased in South Africa. To speak to a consultant today, please click on the link below.